Real medical malpractice story. I was named in a wrongful death suit. By Gina Gallagher. June 1, 2023. Berksea is a division of Berkshire Hathaway Specialty Insurance and ICE 50's dental malpractice partner. Hi, I am Ashley, an ICE 50 avatar presenting this interesting lecture. Read on for Kim's medical malpractice story, how her insurance company helped her through, and Kim's suggestions for easy ways to make sure you're prepared if this happens to you. The suit was from the family of a patient who sustained bed sores while at the facility and eventually died. I specialize in wound care but was contracted by the facility to assess and recommend treatments as well as debride the wounds. Fortunately, she had documentation that supported that, including notes about the dissatisfaction with the facility that the patient's family expressed to her. How Kim got the support she needed. Fortunately for her, she made a pivotal decision earlier in her career that would provide the support she needed. She got her own malpractice insurance with Berksea, part of Berkshire Hathaway Specialty Insurance, so, when she got the news about the lawsuit, she immediately called Berksea. They were looking for at least $250,000 from Kim. She was going through a lot in her personal life and was beside herself thinking she was going to be liable for that money, he recalls. Ed went over Kim's policy and the details of the case. I didn't find any liability on her part, he shares. She had documentation from the facility that provided specific instructions of the care she was contracted to provide. It proved she was not involved in the patient's demise. There was something in those records that probably showed that Kim had no involvement, said Ed, but the facility wasn't being forthcoming. How claims and the lawyer worked together to help Kim fight. As her representative, Ed helped find Kim an attorney from her state. Ed also provided unwavering support for Kim. At one point, the attorney suggested that Berksea may have to give the patient's family a nuisance fee of about $20,000. Kim was adamant that she did nothing wrong and didn't want to pay. I helped that patient on so many levels. I refused to give in and pay anything, she recalls. Ed supported me with that decision. 3 helpful takeaways for other PTs. The rehab facility eventually settled the case, and not unexpectedly, Kim was not found liable. Through this difficult experience, Kim learned some powerful lessons, which she is quick to share with PT colleagues. 1. Get your own malpractice coverage. Even though the facilities where PTs work offer some insurance, every PT should have their own malpractice insurance. 2. Document everything as though you might end up in court. I had written notes when I went in to talk to the administrator about the patient's care, but I could have included more details about the conversations, she points out. In fact, Kim is so passionate about the importance of documentation that she contacted the president of the software company she uses for recording notes and told him about changes they need to make to their program. 3. Understand the value of a good claims team. The process of being sued for malpractice is daunting. A good claims team is so instrumental in not just helping make the process easier, but also in providing the emotional support that comes with having a claim filed against you. Final thoughts. As Kim's story highlights, malpractice claims can happen to anyone at any time. The best defense is having your own malpractice coverage from a provider that offers the support and experience you need to defend the reputation and livelihood you've worked so hard to build. It is my honor to share this lecture with you. Dr. Tom Khalili, ICE 50 founder.